Thanks very much for joining this webinar today. My name is Federica Harnish. I'm European Outreach Officer at ShareAction in the UK. So today's Skillshare is organised as part of the offering of our new European network that brings together civil society organisations that have an interest in campaigning for responsible investment. It's called ERIN, European Responsible Investment Network. We've got lots more of these types of Skillshares planned. For example, at our big conference in June, it'd be excellent to have you involved. Do get in touch if you want any more info on that. So we put this webinar on today we've heard from lots of people that a narrow interpretation of fiduciary duty is frequently mentioned as a barrier to sustainable investment. We've got some excellent speakers involved who will feed back on a few things that you may be able to say when fiduciary duty is mentioned as a counter-argument against sustainable investment, but they'll also provide an overview of the latest policy developments and some opportunities for intervention there. We do, of course, encourage questions, and if you could mute your microphone while you're not speaking, that'd be excellent. And we'll have time for questions after each speaking slot. And we've got 4 speakers involved today. So first of all, we're kicking off with a perspective on the UK, where we have Rachel Haworth, our policy officer at ShareAction, and Natalie Smith, who's a company and financial lawyer at ClientEarth. So they'll be presenting together, as they're also in real life working together on creating greater legal clarity when it comes to climate resilient investment of pension funds. And we also have Brian Tomlinson, Associate Director of Fiduciary Duties at PRI and the UNEP Finance Initiative, who's dialing in from New York, will be feeding back on the PRI's new work stream on fiduciary duty and the US perspective. And we've got Paige, Morrow from Frank Bold, who will be talking about the EU policy level and some potential advocacy activities. I don't want to speak for too long because we have not a huge amount of time. I'll let Rachel kick off. There's already a question, and we'll definitely share the presentations afterwards, so no need to write it all down. And one other comment, we are recording this session. If you've got any problems with that, don't want that, then do let me know by email afterwards. Excellent. So over to Rachel.
Great, let me just show you that. Hi everyone. So as Frederic has mentioned, I'm going to be talking about fiduciary duty in the UK, as will Natalie Smith from ClientEarth. So I'm just going to start with an introduction. Fiduciary duty is about ensuring that the people entrusted to act on behalf of others do so in a reasonable and responsible way, and they don't abuse their position for their own ends. But in an investment context, this core protective purpose often seems to have been forgotten, and it's been replaced by the myth of a single fiduciary duty to maximise financial returns. In March 2013, the government asked the Law Commission to examine the fiduciary duties of investment intermediaries. A central concern in this was the legal duties of pension trustees when they make investment decisions. So in particular, how far may or must trustees consider interest beyond the maximisation of financial return, such as questions of environmental or social impact, and also the ethical views of the beneficiaries of the schemes. So what happens, for example, if a trustee is concerned about how climate change may affect the investment returns of the fund, or if a member of the pension scheme has views on the ethics of tobacco and doesn't want their money to be invested in the sector. Natalie's going to talk about this further in discussing the legal background. Natalie, are you there?
Can you hear me?
Yes, perfect.
Perfect. Sorry, I was just unmuting myself. Thank you very much, Rachel. I would like to start off by briefly discussing a few key legal events in recent history to provide some background and to set the scene for the UK legal perspective. I will then go on to discuss the concept of fiduciary duty itself and its status under UK law, which will hopefully provide a good segue into the discussion around persistent misconceptions and barriers to responsible investment. So starting then with the key legal events. The first event I would like to address is the case of Cohen versus Scargill, which was decided in 1985. This case is often cited as having spawned the debate around whether exercising fiduciary duty, which effectively requires acting in the best interests of beneficiaries, means acting exclusively in their best financial interest, or alternatively whether ESG concerns could also be taken into account in investment decisions. Very briefly, the case involved 5 trustees refusing to approve an investment plan unless it was amended to prohibit investments in overseas companies or in oil and gas. Mr. Scargill, one of the 5 trustees who argued the case, said that such investments were against union policy and therefore against beneficiaries' interest. He said he would maintain this position even if it resulted in financial detriment to the fund. The other trustees in the situation said that this would be a breach of fiduciary duty, and the court in that case agreed. According to the court, the duty of trustees, I should say, was to put the interests of beneficiaries first, and normally this meant their best financial interest. So as you can imagine, as a result of this case, ESG concerns in relation to investments came to be seen as marginal or secondary, whereby those in the investment chain began considering ESG concerns as separate and largely distinct from pure financial concerns to investment portfolios. I'll get back to this divide in just a moment when discussing the Law Commission report, but I'll move on to discussing another case which was decided 13 years after Cohen versus Scargill, and this is the case of Bristol and West Building Society versus Mosquito. That was decided in 1998. The court issued a fairly stern warning against overuse of the term fiduciary duty, which historically captured a wide breadth of duties, such as the duty to exercise duty of care and the duty to exercise certain powers, such as investment powers. Again, very briefly, the case involved mortgage lenders trying to recover losses from valuers and solicitors after the property prices collapsed in the early 1990s. According to a judge in that case, the claimants were seeking to rely on breach of trust and fiduciary duty principles because rules of causation and remoteness of damage would prevent them from recovering all of their losses. So the court in that case held that it wasn't appropriate to impose generous damages or compensation in cases where a fiduciary hadn't acted dishonestly or intentionally, but merely due to oversight. In other words, the court in that case held that mere incompetence wasn't enough, that the breach of fiduciary duty required disloyalty or infidelity. So if everyone can keep that narrow definition in mind for the time being, and I'll come back to it in just a moment, after I discuss the last event in my chronology, which is the Law Commission report. Many of you will be familiar with this report. It was published in 2014 and was prompted by a review of the UK equity markets by Professor Kay, who identified short-term investment practices as a central problem. The Law Commission, seeking to clarify fiduciary law for those in the investment chain, made some key findings in its report. One is that pension fund trustees should consider material financial risks when making investment choices, and that they may take into account any financial factor, even of an ESG nature, that is of relevance to the performance of an investment. The Law Commission found that trustees may also consider non-financial factors, so long as one, they have good reasons to think that members would share the concern, and two, there is no risk of significant financial detriment to the fund. Finally, the Law Commission concluded that trustees are not required to maximize returns in the short term at the expense of risks over the long term. Very pertinent to our discussion here. So that's the chronology. I'll just spend a minute or two addressing the concept of fiduciary duty itself, which I started to do briefly when talking about the Bristol and Building case. So as I alluded to, the term fiduciary duty was used in the past to capture a wide variety of duties. Courts in the UK, however, have been cautioning against using the term in a broad way. The case of Henderson versus Merit Syndicates, the court went so far as to say that the phrase is actually quite a dangerous one. Might be a bit of a big term to use there, but nonetheless a dangerous one, giving rise to the mistaken assumption that all fiduciaries owe the same set of duties in different circumstances, which is not the case. So what does fiduciary duty actually mean, and what place does it have, if any, in the UK legal system? At its core, it means a duty of loyalty. It arises in situations where one person is given authority to act or to exercise power on behalf of another. There is an inherent element of trust and confidence between the parties. So another way of describing this is that a fiduciary is expected to put someone else's interests above their own. So in the case of a pension fund trustee, the trustee is expected to act in the best and sole interest of the beneficiary. Fiduciary duty effectively supplements other positive duties, such as the duty to act with reasonable care and skill, and the duty to exercise certain prescribed powers. So this means, in order to understand the full scope of a fiduciary's duties, one needs to really look at legislation and or principles of common law to find out what those duties are, how they're exercised, and why. And these duties will be particular to each fiduciary. So a pension fund trustee will owe different duties to company directors, and yet both are in fiduciary capacities. All of that is to say the term fiduciary duty in the UK legal context is fairly limited. It necessarily sits alongside other positive, more defined duties. So there you have it. Over back to you, Rachel.
Okay, thanks very much, Natalie. So in terms of the kind of core thrust of what we're talking about today, having looked at the legal background, examples of misconceptions of fiduciary duty, even after the Law Commission's clarifications have been made, which prevent environmental, social and governance ESG factors being taken into account. On the financial side, looking at environmental, social, governance factors which may have financial implications for the returns of the fund, there was a publicly reported exchange between the trustees of the Parliamentary Contributory Pension Fund, which is slightly more easily known as the PCPF, and a group of its members, where members wrote to the PCPF asking about its investment in carbon-heavy industries and the assessment that had been made of the risk that climate change posed to the fund. It was reported in The Guardian that the PCPF chair replied that the trustees' lawyer, sorry, I'm just going to click on to the next slide, I just realised I've done that, had replied to say that the trustees' lawyers had advised that for the trustees to exclude a sector would be incompatible with their legal and fiduciary duties of investment, and that as MPs held a wide range of views, it would be impossible for them to share a moral viewpoint in one area of investment. The members obviously challenged this characterisation of climate change as a moral viewpoint, stating that climate change has significant financial implications for pension funds and is not merely a matter of morals or ethics. And to this, the chair replied that he had to go on the basis of advice he was given by investment managers who were saying to the contrary. Other trustees were similarly minded to go on the advice of the fund's lawyers and other advisors. And we were obviously concerned about this report for the following reasons. Climate change is widely understood to be a financially material factor. Much economic research has shown the impact it could have on the financial value of investments, and this has obviously been argued by key figures such as the Governor of the Bank of England. The fact that trustees of the PCPF and their advisors appeared to characterise it as purely moral was troubling. And even if climate change were a moral concern, the trustees and their advisors appear to have misunderstood the Law Commission's findings, that they were still able to take this into account as non-financial factors may be relevant to trustees' decisions. The Chair's view that to do so would be impossible because of the wide range of members' viewpoints runs counter to the Law Commission's lengthy discussion about seeking to understand members' views and to take into account their concerns. And then the fallback response appears to be that the trustees were delegating this issue to their advisors. And while, of course, it is appropriate for trustees to seek and listen to advice, this does emphasise just how much trustees rely on their advisors, and therefore the importance of those advisors having very clear guidance in law about the full nature of trustees' duties. So on the non-financial side, despite numerous statements to the contrary from government and regulators, there remains an overwhelming perception among such schemes that savers' ethical views can't lawfully be taken into account. And this attitude is typified by one response that a pension saver received to an email they sent via our website in 2010. The trustees have a legal duty to not only invest, but to actively seek the best possible financial return, even if it is contrary to the personal, moral, political or social views of the trustees or beneficiaries. And this has remained a problem even after the Law Commission's clarifications were made in 2014. I actually received an email from a scheme just half an hour ago stating that it couldn't take members' concerns about the living wage into account as they had requested, because the pension fund's fiduciary duty was to achieve the best possible investment return for the fund. This view continues to be used to justify refusals to consider ethical, non-financial grounds in making investment decisions. And this is obviously concerning because it demonstrates a lack of familiarity with the Law Commission's findings. So in terms of achieving greater clarity, what the barriers actually are, obviously, as I've discussed, the misconception that fiduciary duty means that asset owners have to focus on the maximisation of financial returns at the expense of any other factors. The lack of clear legal guidance that pension trustees' fiduciary duties do not prevent them from considering long-term factors, including ESG factors, in their investment decisions. There's a lack of oversight and enforcement, ensuring that signatories to the Stewardship Code are actually complying with its principles. And also the lack of explicit attention on environmental and social issues in the Stewardship Code, which are really barely mentioned. And this corresponds with the general views of investors, which show that social and environmental risks are generally seen as of lesser concern. ShareAction, in its 2015 survey of the 33 largest asset managers, showed that only 42% of the asset managers we surveyed publicly disclosed policies on how they incorporate environmental and social considerations into the investment process. Only 17% of survey respondents said they'd be willing to attend a company AGM to engage on an environmental issue, and 13% for wider social issues. So there's a real focus on governance as the only real important part of ESG factors at the expense of environmental and social concerns. And obviously in the case of things like the Volkswagen scandal and the various emission testing issues there was an enormous drop in share value, and it just shows that environmental concerns aren't just significant in the long term. The risks that companies are exposed to or create can also crystallise in the shorter term. And there's also a vicious circle, because investment consultants and managers tend to wait for client demand before taking action on ESG issues. It's something that we receive feedback on a lot, whereas asset owners tend to rely on advice given by their consultants and managers on these issues. So if neither party are immediately taking responsibility for having these conversations about how ESG factors should be taken into account, then they never will be. So that's something that needs to be thought about. And also the fact that members of contract-based schemes are subject to lower standards of protection in the first place, as the same fiduciary duty doesn't apply, and the FCA is treating customers fairly. Rules don't impose duties on providers to put members' interests first. So in terms of then how to overcome these barriers, for our policy recommendations, we believe that the Department for Work and Pensions should clarify that pension trustees' fiduciary duties do not prevent them from considering long-term factors, including ESG factors, in their investment decisions. They should require trustees to explain how they ensure that their investment managers follow their policies, and also require trustees to report on the implementation of their policies annually in their annual investment report. This, we think, would reduce the tendency towards vague boilerplate statements in their statement of investment principles, where they often just say that they delegate all decisions relating to ESG factors to their investment managers. The Financial Reporting Council should revise the Stewardship Code to promote stewardship on environmental and social issues within companies, educate investors on best practice by facilitating more discussions between asset owners and asset managers to clarify the type and format of information which would be of most use, and enforce the code so that there are consequences for poor compliance and good practices rewarded. And the FRC is currently in the process of looking at this year. Results to be announced. The pensions regulator should seek to facilitate and support funds engaging with their members, and again, positive news is that the new draft defined contribution code now includes the requirement to engage with members on their views and should include guidance on how to do that, and encourage smaller schemes to consolidate, because smaller schemes often have insufficient resources to demand, manage and monitor sustainability activities. We also recommend that the Financial Conduct Authority should strengthen the rules for contract-based pension schemes so that savers' best interests are being put first by the product provider. And then in terms of recommendations for investors, corporate pension funds should make sure that they sign the Stewardship Code and make public commitments to responsible investment. Funds should consult with Funds should consult with members and encourage and welcome member engagement, particularly by providing full and open disclosures on their investment policies and practices. Funds should consider how they can embed appropriate incentives in asset managers' contracts, for example, longer-term performance measures on a wider range of factors. DC pension providers should assess members' views and offer an ethical fund option based on that assessment. And they should avoid and manage conflicts of interest within trustee board and service providers, particularly requesting information from asset managers on how they manage conflicts. So that's everything from me. Did you want to do questions now or wait until the end?
Yeah, we could, if there's any questions now, feel free to ask them. Just remember to unmute your microphone, or you could write into the chat box as well. Otherwise, we'll move on to Ryan and we'll take some more questions later.
Lars from Denmark here. Just a quick question on, this was UK law and where the call is within the context of European Responsible Investor Network. The Solvency II regulation works with prudent person that has some of the elements of fiduciary duty, and in general many European countries have a civil law rather than a common law system. Just a few comments on how the UK would expand to Europe.
Natalie, do you think that's a question that's best suited for you, or I can take it?
I'm not sure if I'm best placed. Perhaps once we hear from Paige, we can come back to it. How does that sound?
Yeah.
Fine.
Okay. Well, yes. If we wait for Paige's session and then we can take that question together. In terms of, there's another question that's come up in the chat box from Miriam. In terms of what the Stewardship Code actually is, it's the code that is looked after by the Financial Reporting Council, which is a voluntary code investors and asset owners can sign up to, and it consists of 7 principles, which signatories have to report on to show how they have been complying with the principles of the code, which essentially all revolve around how to steward companies and make sure that companies are being managed for the long-term best performance. So often to do with governance, also to do with environmental and social factors, conflict, management of conflicts of interest and that kind of thing.
Brilliant. Okay. I think we need to move on to Brian because Brian has to leave in 15 to 20 minutes. So Brian, are you happy to kick off with your presentation?
Yeah, absolutely. Good morning, everyone. Thanks for getting on the call. So I wanted to quickly give an overview of our project on fiduciary duties, which is a combined project of PRI, UNEP FI, and the Generation Foundation, which we kicked off in January 2016. It has very much as a focus integrating ESG factors into mainstream investment practice. The project has three critical elements to it. One is developing roadmaps for implementation of ESG through the investment process in 8 different jurisdictions. Then we're going to recut our work for fiduciary duty in Asia to establish a benchmark in those jurisdictions. And then we're also going to promulgate an international statement on the expectations internationally of the content of fiduciary duty. Our approach here is that essentially we're using fiduciary duty as a lens through which to look at the investment industry, and then having looked at the investment industry through that lens, we're then able to recommend a whole series of levers which we can use in terms of public policy and investment practice to implement ESG throughout the investment chain. In terms of background, and perhaps to sort of reiterate some of the comments that have already been made, I think it's useful to think about why we're talking about fiduciary duty. Obviously, fiduciary duty has been identified as a barrier to ESG integration. I mean, and our take on this is that that's very unhelpful and it really shouldn't be. But we can only sort of move away from that when we think about sort of why fiduciary duty is so important. And fiduciary duty is for us sort of foundational for the investment industry. Depending on how you look at it, depending on where you get to, it helps to frame assumptions about appropriate investment behavior. And fundamentally, fiduciary duty, its concept is a response to complexity. Each of us in our individual capacities probably are not sophisticated enough or well-informed enough to provide safely for ourselves in retirement. So what do? We hand that responsibility to a fiduciary. And so, in a sense, fiduciaries then become representatives of the public interest embedded in the financial system. So what we would expect is that a fiduciary status should compel reflection on how best to perform their duties, how best to guarantee the appropriate sustainable returns to provide safely for people in their retirement. But that reflection should also be because the investment context is not static, it's very complicated. Complying with your fiduciary duties are far from mechanistic. I think a sense is abroad that being a fiduciary is in many ways just a simple sort of mathematical totting up of assets against liabilities, or actually there are many different ways of doing that, and it's a very wide field for the application of discretion. So we want to sort of see fiduciaries embrace, in the words of SEC Commissioner Gallagher, a fiduciary mindset, which is a very reflective, thoughtful mindset about how you comply with your duties, rather than it sort of being a tick box exercise. Now, but it is clear that though fiduciary duty is full of this potential, it has been sort of unhelpfully misinterpreted, and its sort of space for discretion has been met with uncertainty, risk aversion, and misunderstandings. And it feels like those misunderstandings fit into 2 broad categories. One is about the meaning of ESG, and one is about the content of fiduciary duty in itself. I think there's often been, in a sense, an unhelpful lexicon that's been used around ESG factors, where people have confused ESG with essentially imposing an ethical preference into the investment decision, and asking fiduciaries to essentially subsume the purposes of the trust, which is to provide a pension, to what in English law you'd sort of call the irrelevant considerations beyond providing a pension. So that sort of misunderstanding, I think, has to be addressed. And then also there's the content of fiduciary duty, which Natalie spoke to particularly earlier on, about what are the requirements of fiduciary duty, what does it mean in practice in the investment context. And that then takes us to the findings of our report last year, Fiduciary Duty in the 21st Century, which sought to sort of wipe the slate clean and establish what we think is the modern benchmark, the modern interpretation of fiduciary duty. And that takes us in a number of very helpful directions. Firstly, that report found that fiduciary duty was not a legitimate barrier to ESG integration. It provided that the failure to consider long-term investment drivers, of which obviously ESG is a core element, is a failure of fiduciary duty. There's no discretion to not consider factors that are financially material, and obviously there's a whole world of investment decisions in which ESG will be a crucial financially material element. And also, helpfully, particularly in the context of climate change and a range of other externalities, fiduciaries may consider systemic risks where they are mandate relevant. So that was the finding, a sort of a global finding on fiduciary duty, which then has been both subsequently and prior to that reinforced both in the US and the UK. Again, Natalie spoke about the Law Commission finding earlier, which was extremely helpful, and their language, I think, was relatively unambiguous in the context of ESG factors being financially material. There is no impediment to considering them. In the US context, very helpful clarification was provided by the US Department of Labor last year, which asserted that ESG issues can be part of the primary analysis of prudent investment decision making. Now, that is an extremely important development in the US market, arguably the most important for the last 5 to 10 years. That interpretive bulletin, can you mute your line, whoever it is? That bulletin released in November, October-November last year, Interpretive Bulletin 2015-01, which provided that clarification, replaced a very unhelpful interpretive bulletin that was released in 2008, which revolved around economically targeted investments. And what that 2008 interpretive bulletin said essentially was that investing which took account of environmental and social governance factors, which it called ETIs, economically targeted investing, would be extremely rare, and it wouldn't be essentially a mainstream investment practice. And indeed, if you were going to consider those factors in the investment decision, then you had to prove that there would be no financial detriment to doing so, and you could only do it if assessed against another asset of a similar type, there would be no detriment to doing ETIs. So almost like a tie-break test. So obviously this was designed to have a very significant chilling effect on the ability of fiduciary investors in the US to take account of ESG factors. So that guidance has now been withdrawn. That creates a lot of open field for fiduciaries in the US to consider ESG factors within their investment decision. Now, the language of that interpretive bulletin is sort of quite careful. It's essentially sort of indicates that ESG issues can be part of the primary analysis. And I think many people would have, particularly in our sort of space, would have been pleased to see a more positive duty. However, I think in a number of situations, the difference between can do ESG and should do ESG is essentially vanishingly small, because there are going to be a whole range of circumstances where the ESG elements within an investment decision are so clearly financially material to not take them into account in a reasonable way is going to create a very sort of powerful sort of incentive to consider them within the investment decision. So in a sense, it sort of flips the arbitrage in a way, or it flips the analysis. I think investors previously were worried that if they didn't integrate, if they did integrate ESG into their investment decisions, they opened themselves up to be sued because of the unhelpful drafting of the previous interpretive bulletin. Now there's the potential that we've kind of flipped that the other way around, and actually that there could be nervousness around being sued because you haven't incorporated ESG into your investment decision. So it creates a very strong permissive environment for the consideration of ESG in the investment market, and it's a very positive development. That's also supported by the sort of SEC's interpretive guidance that was issued a few years ago, which indicated that companies should disclose specifically against climate change within its 10K reporting architecture. That's, I think, extremely important because it makes it quite clear that ESG issues are financially material. They can pass that materiality test, and they would therefore be of interest to investors in reporting companies. So it all goes to build a picture that there is momentum for the consideration of ESG in the investment decision. And if you look at what some of the fund managers have said in the US as well, the letters by sort of State Street, BlackRock and Vanguard, they've said that they're beginning to incorporate ESG as a central part of their fund management practice. Because that also indicates that one of the important ways in which you judge what is and is not appropriate investment behavior is by judging it against your peers, i.e. market practice will, to an extent, dictate what is and is not reasonable. So then our project and that background leads us to make a series of recommendations, which I won't talk through in too much detail. They are similar in the UK to those which ShareAction helpfully outlined earlier. In the US, you can see we have a focus on stewardship. We want to see better engagement with investee companies, and we regard the proxy process as being an interesting way of reinforcing that. We want to see across the piece state funds incorporating ESG into their plan governance. We do think the nexus with the investment consultant community is extremely important, and we want to see trustees becoming much more intentional in terms of the advice that they request from their investment consultants. Fundamentally, trustees need to realize that clients shape the industries that serve them, and I think trustees have often been quite bad at acknowledging that. And then we've got a series of other recommendations on stock exchanges and corporate reporting. And there's a similar sort of thematic element to the proposed recommendations in the UK. So just to conclude, I suppose, no matter what the context of or content rather of fiduciary duties are, no matter what the lawyers say, ultimately a lot of getting the mainstream moving and incorporating ESG is about overcoming industry skepticism. We think there's a compelling evidence base linking ESG with better corporate and investment performance, from the CalPERS effect to doing well by doing good, the shared value paradigm, ESG management as just being a proxy for management quality. We see that essentially ESG is what good, smart, prudent investors ought to do, and we want to see the industry getting a lot better at reporting that link between ESG incorporation and corporate performance. So that's our project, and that's a sort of little bit of the US and the UK. Happy to take questions.
Yeah, thanks very much, Brian. Do you have any questions?
I have a question.
Yeah?
Frederica. Hi, it's Liz Umlis.
Hi.
I have a question. Hi, following up on Brian's point about the alignment of ESG factors and financial materiality. So yes, in the long term, ESG factors should turn out to be financially material, but I think it's still true that in a number of important cases it could be hard to prove, for example, certain human rights issues that are financially material in the short term or the medium term. So I wonder, does that not mean that the financially material directive, for example, of the UK Law Commission findings, would still leave us with the requirement that we have to make a business case for those human rights issues, and if you can't, then it doesn't have to be taken into account?
Yeah, I suppose there are a number of different levels at which we can sort of engage with this. I mean, our case is very much an investment case. We essentially think that depending on the dimension, depending on the issue, ESG is likely to be financially material, and therefore, we're essentially using that fact, that empirical fact about the investment space to get the skeptical part of the financial community to embrace ESG, because essentially they can see it as a way of doing their job as investment managers and trustees better. There is, I suppose there then is a different case which is sort of beyond financial materiality, where there is going to be a higher test, a more difficult test about how you can use those factors, those ESG factors that are not financially material within the investment decision. But our focus is very much on those which are financially material.
And I think as Brian has nicely drawn out there, that you can engage with these issues on various levels. So obviously human rights issues can be financially material, in that there's increasingly legislation on enforced labour and that side of human rights. And you know, from a kind of PR perspective, there have been a lot of studies done which draw a strong link between financial performance of companies and, for example, the lower cost of capital, because that company has a great reputation and therefore can, you know, is able to acquire capital much more cheaply. On the non-financial side, as we've mentioned in the Law Commission report, I know this isn't the focus of the PRI at the moment, but if beneficiaries of the pension scheme get in touch and say, we really care about human rights and we're very concerned about the companies that we will be investing in, then if there are a number of letters that come from beneficiaries saying this, then trustees can take that into account when they're making their investment decisions. So there are two ways of looking at it, and often they fall into the same camp. I guess the example that's usually used in terms of non-financial factors are tobacco, because it's hard to show in the current climate that that's going to be a financially material issue, but it's something a lot of people care about from a non-financial perspective. But usually you can look at issues in a couple of different levels.
Excellent. Maria, there's not a huge amount of time for questions, and we need to move on to Paige. But if you have more questions for Brian or for Rachel, Natalie, or in general afterwards, I'm very happy to collate those questions. We can correspond by email. So Paige, over to you.
Great, thank you so much for having me. I'm just going to quickly go through the general lay of the land in continental Europe and a couple of recent initiatives to address fiduciary duties or their analogous equivalents at the EU level. To just quickly address one of the questions that came in before about the equivalent duties in continental Europe. Are you still able to hear me?
Yeah.
Okay. Sorry, I wasn't sure if I got cut off. The concept of fiduciary duties obviously comes from common law, and there does tend to be analogous concepts in civil law systems. but they don't tend to be referred explicitly to in the context of institutional investors. Ernst & Young did a study that was requested by the European Commission, and while they didn't systematically map out fiduciary duties across Europe, they did look at 7 member states, namely France, Italy, Germany, the Netherlands, Denmark, Poland, and Latvia. And in their survey, they relied quite heavily on the work of an earlier report that was done by Freshfields for UNEP back in 2005. And in all of this work, they have arrived at a similar conclusion, which is that the duty to act in the best interests of beneficiaries typically involves some obligation to prioritize profitability or achieve highest returns, but no jurisdiction, including continental Europe, prescribes a particular level of profitability or financial return, and some countries have qualified this explicitly. So, for example, in Germany, there's non-binding guidance indicating that the profit must be sustainable. Additionally, there is the duty to act prudently, which might be expressed in different terms in continental Europe, such as diligently in Spain or prudently in France. But in each case, it does involve a requirement to consider adequate diversification and the risks and liabilities of investments, which could be interpreted to include environmental and social risk. There are also a couple interesting examples where, although the term fiduciary duty isn't used explicitly, there is some recognition of the importance of environmental and social risk. So, for example, in July of 2015, France passed the Energy Transition Law, and that will requires institutional investors to include in their annual report and make available to their beneficiaries information on how their investment decision-making process takes ESG criteria into consideration and the means implemented to contribute to the financing of the ecological and energy transition. In the slides that I have, there's a link to the Ernst & Young report that was produced for DG Environment, and at page 29 they do provide some information of the mapping out of the different member states that they looked at, including Denmark, which I think was the jurisdiction that was in question earlier in the call. The main conclusion, however, was that oversight is weak. So to take a concrete example, German financial supervisor BaFin does have a mandate to look at ESG considerations by institutional investors, but this doesn't look into the quality of the investment decisions. The Ernst & Young team came up with several recommendations that have been in line with other similar proposals from earlier studies. So, for example, they suggested that national financial authorities with support from the European Commission provide official guidance to interpret fiduciary duties, both in the UK and elsewhere. It should be noted here that what they see by support is not a direct legal intervention, but rather guidance, clarification. They explicitly advise that they do not suggest any legal intervention, and their rationale was rather interesting. Their thinking was that although introducing legal requirements to specifically address ESG issues, such as if resource efficiency could be foreseen, they would not necessarily be very effective. While a statutory provision would free trustees to exercise their professional judgment about best interests, that alone might not necessarily lead to any change. So rather than suggesting that as well as additional support, they simply stated that it was not considered to be effective to have specific legal clarification, but rather provide tools such as a reference document to explicit sort of flesh out how ESG considerations should be reviewed, and then they have certain disclosure recommendations about responsible investment policies, etc. That ties in with the next point, which is about the Shareholder Rights Directive. So the Shareholder Rights Directive provides a floor of shareholder rights across the European Union, as suggested by the title. And in the context of the current revision of the directive, which is still ongoing, one of the proposals, which was put forward and supported by ShareAction as well as other civil society organizations, was the mandatory disclosure of responsible investment policies by institutional investors, including whether or not they have such a policy in place, meaning on a comply or explain basis. And this policy would include monitoring investee companies to reduce environmental and social risk, as well as how the policy was implemented and the results of it. This was part of a number of changes to the Shareholder Rights Directive, which at this moment in time is still in trialogue negotiations between the European Parliament, Commission, and Council. So we don't necessarily know exactly how that will go. It will likely depend on the provisions on country-by-country reporting on tax transparency. So we may have some indication in the next couple of months. Knowing that time is brief, I'll leave that with the Shareholder Rights Directive, and I'll just flesh out a couple of the policy recommendations that were mentioned earlier. So the Ernst & Young report emphasized the need for clarification at either the EU and or the member state level regarding the scope of discretion available to pension fund and other institutional investors, how to consider ESG matters. One way that this could be implemented in practice would be a recommendation from the Commission to clarify minimum expectations across the EU, and at the very least provide clear guidance that they may be considered, and in some instances, such as where there's clear indications from beneficiaries that they wish it to be considered, that it in fact is required to. There's been a lot of work in the UK, less so in continental Europe, so arguably a recommendation, even though it's non-binding, could provide interesting and influential guidance to both member states and to trustees. Two more options that have not been discussed in as much detail would be readjusting asset managers' mandates or benchmarks to integrate ESG criteria, and possibly look at clawbacks. So if asset managers fail to adequately consider ESG risks, and those risks were to later materialize, that there would be a contractual clause allowing that to be within, say, a specified period of time, 1 or 2 years. So I'll leave it there, but happy to answer any other questions that you might have.
Yeah, do let us know if you've got questions. I have one question. Camilla at ShareAction. Is Brian still on the call? I'm not sure. Brian, are you still there? You might have left. Okay. As I said, we can, yeah, coordinate some questions. Miriam is asking what the DG environment does as a follow-up.
I've spoken a couple different times to various individuals at DG Environment. They don't have a specific list of action points from the study, which is a bit disappointing. A part of it is that they're a bit hamstrung in that any meaningful change in the area of fiduciary duties would not come from DG Environment, but would rather come from DG Justice, which is responsible for corporate governance and company law. So that being said, though, they've said that they will be looking at further action that they could take in the area. Also, DG Justice, of course, just closed their consultation on long-term and sustainable investment at the end of March. And so we may see a lot of the conclusions and the policy recommendations that were brought up by Ernst & Young coming up now again in the context of this consultation done by DG Justice, which would be promising because they would be the ones that would have the ability to act on it.
So there is also a chance in the IOPS directive, which covers pension funds, that they're going to amend the article where it mentions the prudent person principle. And the wording that's made it through the Parliament vote is not ideal in terms of clarifying this issue, because
what it says is that someone investing in accordance with the prudent person principle may take account of the impact their investments have on environmental, social, governance or ethical issues. But it doesn't also say the other way around, that they may take account of how ESG issues impact the investments themselves. But I think if it did get clarified in one text, it would have knock-on implications for kind of other areas where the prudent person principle is enshrined in EU law.
Sebastian is asking, what could we ask the European Commission exactly in terms of clarification and in what format? Anything that does not require to amend existing EU legislations, which is very slow and heavy?
Well, the idea of the Commission putting forward a recommendation on fiduciary duties would get around the issue of having to go back through Parliament and the Council, because the Commission itself has the ability to issue recommendations. Now, the downside is they're not binding, but they can be quite influential, and they tend to be seen as a signal that the EU or the Commission will introduce legislation on an issue if the member states fail to act. And it can be a good signal where there's confusion or a lack of clarity, which may be the case here. They have issued recommendations, several recommendations on corporate governance and company law in the past, so it's certainly not outside, it's certainly not out of the question that they would do it on this as well. It's limited, it's simply, I mean, sort of limited in its ability to actually make meaningful progress, but in terms of taking some of the work that's been done by these Ernst & Young reports and by UNPRI, it can be, it has a little bit more weight.
Excellent. Okay, we've got one last question from Joel. He's asking, how would they integrate ESG into benchmarks by exclusions, and whether there's anything else? Joel, would you? Yeah, sorry. Oh, yeah,
sorry. Well, I'll give just the 10-second version, and then I'll turn it over to others that might be able to flesh it out as well. On the, exclusion is one category. I mean, there also has been work done on developing benchmarks that specifically address environmental and social risk, and I think that could be an interesting way for the future, but I'll turn it over to others.
Okay. Any other additions? Teresa, I think you can also just ask a question. You should be able to without being a moderator. Okay. Okay, it was a typo. Anyway, I'm aware that people are now leaving and we should probably close now. As said, I'm happy to collate questions and pass those on to the speakers, and we'll share the slides and the recording as well. I'm sorry there was not quite as much time for questions as I promised there would be, but yeah, hopefully we can keep on talking about this. Thanks so much to our excellent speakers. It was an excellent overview. Thanks for everyone for listening, and hope to be in touch soon.